Assalamu alaikum warahmatullahi wabarakatuh. I would give you a brief introduction of Mr. Joseph Abraham. Mashallah, he is from Kerala, but now he is in Delhi. Looks after all minorities and other cases also. He is an advocate on record, Supreme Court. And we have been I think long associations with Jan Abraham sir. He is a very close friend of ours, and he takes a lot of pain for those things. These days most of our friends, I think, do not know, mostly the minorities actually challenges and the rights and everything. He is very much aware of everything. And one thing, for our institutions, he has helped a lot, and in obtaining minority certificates and all. Firstly, we tried from Hyderabad, but could not get it. So, mashallah, we went and met him in Delhi. He has done wonderful job for us. So, mashallah, as such, what we have minority certificates and all with us. These are the efforts of Joseph Abraham Sahab. So, what I want actually, he had been to Hyderabad, so he's there for 2 more days, I believe. We came to know that he's just coming for the sessions in Hyderabad. We thought that this is the best opportunity we must grab, and we must have such personalities, best his experiences and all. So we discussed in AME, Sajid Bhai, me, Anwar Bhai and all, Vikhar Bhai and all. So we thought of gathering you all. So inshallah, now sir will speak to you, sir will address you, and your queries also can be discussed. Your concerns can also be discussed here. And most of our friends are online, and MS team and other members also hybrid meeting. So only we have gathered here, as I mentioned, only these are the school key leaders. They are just running their best institutions. Individuals in the capacity of 4, 5, 6 like that, they are running those institutions. For them only we have gathered. You may proceed, please.
Respected Anwar Sahib, other dignitaries, dear friends, we are all gathered here to discuss on minority rights under Article 30, Subclause 1 of the Constitution of India. As our Anwar Sahib rightly pointed out, many of our institutions are already obtained the minority status certificate, and few may be on the process of obtaining minority status certificate. Ultimately, we are claiming our minority rights under Article 30. So let me begin this session with a question. I hope the people are joining through virtual mode. They can raise their questions in the chat box, right? So somebody can read it so that I can answer it, right? So instead of a one-way traffic, I would like to make it as an interactive session. So any doubt, just raise your question then and there itself, so that I can clarify your doubts initially itself, or else at the end of presentation, let us have a small interactive session also. My initial question for this session is, what is minority right? We have minority certificate for many of our institutions, or some are on the process of getting minority certificate. So we should have a clear understanding what is minority right. Nowadays, in our institutions, we may be getting a lot of queries under Right to Information Act, RTI Act. Every institution may be getting RTI queries. We need so and so information. And some institution may be responding by stating that we are a minority institution, so we will not give you any reply. Or there are certain cases, POCSO is a very dangerous legislation as far as institutions are concerned, because by applying POCSO, a lot of cases are filing against the teaching staff or non-teaching staff in the schools. So that time also some are saying, this is a minority institution, so no POCSO is applicable. Can you say that these are minority institutions are exempted from these provisions? POCSO or RTI or these kind of general laws, are we exempted? So we should have a clear understanding what exactly the minority right is all about. There are certain areas, yes, we have a minority right. But there are certain areas, as I pointed out, this RTI or POCSO, we cannot say that ours is a minority institution. There is no separate exemption as such. So these kind of confusions are happening only due to the lack of clear understanding regarding minority right. So I hope and trust that at least today's session may enlighten us on getting a clear understanding what exactly the minority right, which are the areas wherein we can get the actual exemption, and which are the areas where is no separate exemption, and we should follow the general laws of the land. Yeah. So the first point for today's discussion is, what is minority right under Article 30, Subclause 1 of the Constitution of India? As you are all aware, the Indian Constitution was enacted and the drafting was actually going on at a time once the partition was happening. A lot of concerns were there at the time of our independence, and even during the drafting of our constitution, there were demands from the minority communities stating that, initially some of the leaders thought that we need a separate electorate so that minorities may get their own representation. But then some of the prominent leaders stated that no, we don't want a separate electorate or representation as such, but let us have a minority right, educational rights of minority rights. And ultimately, the drafting committee was included Article 30, Subclause 1 of the Constitution of India, by which all the minorities, both religious and linguistic, can establish and administer educational institutions of their choice. That is what the language applied in Article 30, Subclause 1 of the Constitution of India. That is what the whole minority right is all about. Yeah. It only says about minorities, both religious and linguistic, can establish and administer educational institutions of their choice. So the language mentioned in Article 30, Subclause 1 of the Constitution of India is only this much: minorities, both religious and linguistic, can establish and administer educational institutions of their choice. In addition to this, there is no clarification, or there is no detailed law or anything as such. So due to this, even during the year 1950 onwards, the cases started to come. What is minority right? What exactly the establishment is all about? What is administration? And what is choice? And what are the rights? What are the advantages? Because Article 30 only says about this much. And then whenever there is a vacuum in the legislation or the constitutional principles, naturally the court will interpret. The constitutional courts, such as the High Courts and the Supreme Court of India, can narrate or explain what exactly the minority rights are all about. So in our case, there are a lot of authoritative pronouncements on minority rights from both High Courts and the Supreme Court of India. And now the whole concept of minority right is very well settled, primarily due to the TMA Pi Foundation case. That is an 11 judges bench of the Supreme Court of India clarified the whole position. What is minority right under Article 30? What are the rights? What are the ways by which this establishment means, administration means, your choice means? Everything is defined by the Supreme Court of India in that larger bench decision of TMA Pi, and there are so many other judgments also. So we will, during this presentation, we will also see what are the minority rights and as settled by the Supreme Court of India. Before we discuss on the rights, let us see. The first point is how to establish a minority educational institutions. I know that Anwar Sahib is already established so many minority institutions, and all the institutions which you have established are minority institutions. But just for the sake of completion of our seminar today, let me say how somebody can establish a minority institution. So as Article 30 says, minorities, both religious and linguistic. Yes, there are two minorities in our country. That is, one is religious minority and the other one is linguistic minority. Religious minority means the government of India has notified there are 6 religious minority communities in India on the basis of religion. So obviously Muslim community, Christian community, Jain community, Sikh community, Buddha and Parsi. These are the 6 religious minority communities in India, and nationally they are declared as minority on the basis of religion. So they can entitled minority rights under Article 30 subclause 1 of the Constitution of India. Here, please note that even though these 6 minorities are notified nationally, there are certain states such as Lakshadweep is a place where Muslims are majority. They are not in minority. Lakshadweep, around 98% of the community is actually from Muslim community. So in Lakshadweep, Muslim community cannot claim minority status. Similarly, in the Union territories, now earlier it was Jammu and Kashmir, that state has actually not in existence now. Now it's Union territory. So both Ladakh and Jammu and Kashmir, again, the Muslims are in majority. So there they cannot claim minority status. Similarly, in the state of Punjab, Punjab is a Sikh dominated area. So in Punjab, Sikhs are not notified as a minority community. Similarly, in northeastern states such as Nagaland and Mizoram, Christians cannot claim minority status. Yes, this is what related to the religious minority. Similarly, the linguistic minority is also recognized as per the Article 30 of the Indian Constitution. I am originally from Kerala, so my language is Malayalam. So outside of Kerala, my language is treated as a linguistic minority. So there are institutions even in Telangana. Yeah, Malayali Samajam schools are there. I can claim linguistic minority. Similarly, Telugu, outside of Telangana and Andhra Pradesh, yeah, outside of this place, in the state of Delhi, there are Telugu medium schools. Telugu linguistic minorities are there. They can also get the same kind of minority rights which are guaranteed under Article 30. So please note that 2 minorities are there. One is on the basis of religion and the other one is based on linguistic. So the linguistic may be the identification and the determination of linguistic minority may be little controversy, but the religious minorities are, to some extent, it is very well defined, and today we are concentrating largely on the aspect of establishment of institutions by religious minorities. So the second point which we would like to discuss is how to establish a minority educational institutions as settled or as established already by our learned friends such as Anwar Sahib. All are minority institutions and we already obtained minority status certificate also. Yes, the first step to establish an institution is to have a legal entity in the form of a religious and charitable society or a religious or charitable trust. Or we can have a section 8 companies also. These are the 3 main areas or 3 main legal entities by which we can establish education institution. That is not only for minority institutions. Any individual, we know that there are not only minority institutions, the majorities are running a large number of institutions in our country. So anybody who would like to establish an institution, the first setup or the first entity we need to create is a trust. It can be a trust or it can be a society or it can be a charitable company as per section 25 of the Companies Act. Earlier section 25 or as per the previous act it is section 8 companies. Companies are basically profitable companies. So, but there are charitable companies. Only charitable companies are permitted to establish these educational institutions. The companies are a very less people are opting for establishment of charitable companies, but 90% of our institutions are actually promoted by either a trust or a society. So I think we have a trust. We have both trust and society, but more institutions nowadays people prefer to establish trust, so that the advantage of trust is that it's a very small entity. Minimum 2 persons can establish a trust. That is what the advantage of an educational trust. But for the purpose of establishment of a society, minimum requirement is 7. But in the society also there is a difference. There are state societies and national society. It means if your area of operation is only limited to one state alone, then you need only a state society. For a state society, you need minimum 7 members from that particular state itself. But if your area of operation is all over India, then you need a national society. For that purpose, you need members from 7 different states, and minimum 9 members are actually required for establishing a national society, so that your area of operation can be extended throughout the country. But trust is concerned, whatever trust you are establishing, automatically you will have you will have an area of operation nationally. That is what the advantage of trust, and that is the reason people are opting for trust. But here the difference between a society and a trust in terms of getting aid from the government and the other funding agencies, there is a difference regarding these two. If you are opting a small entity such as a trust, government may not promote you to get more funds, because it's a very small entity, and being a small entity, the process of democracy and the democratic principle, maybe the chances are limited for a trust. So you may not be able to gain much contribution or donation from the governmental side, or similarly institutions are entitled to get foreign contribution as per FCRA. Yes. So at the time of FCRA also, if it is a trust, then it may be a little difficult to get a clearance from the Ministry of Home Affairs for getting a clearance for a trust. But if you are not aiming fund to be generated by way of contribution from government or from outside of this country, then the safe method for establishment of an institution would be a trust, because it's a very small entity and the scrutiny and the other formalities are also to some extent very limited. But for a society, the procedure may be little longer and more procedures are there, but there are advantages. So obviously there are advantages at some point of time, but there are disadvantages also. So these are the two popular entities for the establishment of an institution, especially minority institution also. The first step is you need to have a entity in the form of a trust or a society or a charitable company. Yes. And then the other question would be, Article 30, as I told, the language says that, the institutions established by religious or linguistic minority can establish and administer institution as per their choice. So here the establishment means, the first step is you are creating a trust or a society. So what would be the founders? Can you admit members from other community as the trustees or the governing body members, and then later can you claim minority status? That is what the important question, because many a times the minority people, what they do is they will take 3 people. Suppose if you are planning to establish a society, then you may take 3 members from Muslim community, 3 members from Christian community, and then another 3 from Sikh or another community, and then you establish it as a minority entity, and then can you claim minority certificate for that? 3 all are from minority, so can you claim minority benefit? For the benefit of minorities, so can we claim the minority benefit? So on that aspect, people are doing it, but that is quite wrong, and we are unable to get the minority certificate or any of the protection under Article 30. For that matter, if you are establishing a Muslim minority institution, then the majority members obviously has to be from that minority community. Similarly, if it is a Christian minority, it has to be from that. The large or the majority members are supposed to be from that religious minority community for the purpose of claiming minority certificate. Now, the word minority, we may be using it as by word minority, which we mean that everybody, all the religious minorities are actually covered under the word minority. So in the objectives also, we will be only saying that it's a minority institution, it's for the minority benefit. Merely saying that is not sufficient. So the founders who establishing a trust or a society, there also they are saying we are applying it as a neutral word, and neutrally we are selecting people from different minorities, but that cannot be entitled, or that cannot give you the freedom or the protection under Article 30, and you cannot claim minority status certificate. So please note that the first thing is establishment of a trust or a society. At that time itself, you should identify which minority are we belong, and which minority are we going to take care or to cater the needs. So both aspect has to be crystal clear in the deed itself. Trust deed means if you are establishing a trust, then naturally you will have a trust deed. If you are establishing a society, then society will be having 3 documents, such as a society will get a registration certificate, then it has a memorandum of association and bylaw or rules and regulation. That is what the society is all about. Similarly, a company is also concerned. There is a certificate of incorporation, articles of association and memorandum of association, the similar documents. So at the time of establishing that entity itself, you should identify and you should have majority members from the very same minority community. If we are establishing a Muslim minority community, ensure that the majority members shall be from that minority community. And in addition to that, there has to be a specific clause in the objectives of a trust deed or the memorandum of association, specifically saying that the institutions established and administered by so and so society or a trust shall be minority institutions, primarily for the benefit of Muslim minority community. It has to be there. We cannot simply say that it is for minority community, or we cannot say that it is for all irrespective of caste, creed, color, religion and sex, because that is what the common word the people may use. But with that, we cannot claim minority status certificate. So that is what the establishment, at the time of establishment of that trust itself, we need to be ensured that the founding members are the key position. So always ensure that we are taking members from our own community only. If you are establishing a Christian institution, ensure that you are having only members from the Christian minority. Similarly, whatever may be the religion, ensure that you are taking only members from that minority community. But obviously, you can have 1 or 2 from outside, because that won't make the majority. This was an interesting issue settled by the Supreme Court in St. Stephen's case. In that matter, this matter was gone up to the Supreme Court, and the Supreme Court settled the position that you can take somebody from outside, but the majority has to be from that minority community. So no mixing up. That's what the very important position. And secondly, there has to be a specific objective in your memorandum of association or the trust deed, saying that it is primarily for the benefit of so and so minority community. Here also, please note that if you are aiming for 12A exemption under Income Tax Act, or Section 80G is also saying about some kind of exemption as per Income Tax Act. 12A says that if your society or the trust is generally, definitely they will be having some income. So if you have 12A registration, then you will get an exemption from filing income tax. That is what 12A is all about. Similarly, 80G is all about donating money from the outsiders. If you have 80G exemption, then whoever is donating money, they will get the exemption. So 12A is directly for the entity, 80G is for the donors. So these are 2 exemption guaranteed under section 12A and 80G of the income tax. So for the purpose of getting an exemption under section 12A and 80G, there is a requirement as per the Income Tax Act stating that you should say that you are catering your institution for all irrespective of caste, creed, color, religion and sex. If you have that objective in your trust deed or the memorandum, then only you can claim 12A or 80G benefit. So please note that as a minority institution, we are entitled for both benefit. We are entitled for minority rights under Article 30. At the same time, we are also entitled for tax exemption, which are mentioned under Section 12A and 80G. So for that purpose, please note that you are writing both things in your objective. We should say that all the institutions established and administered by so and so trust or society are minority institutions covered under Article 30 subclause 1 of the Constitution of India, primarily for the benefit of Muslim community. However, admissions are open for all, irrespective of caste, creed, color, religion and sex. That is what we are doing. We are in every institution, primarily we are serving for our own community, but we are not denying admission to outsiders. That we need to say if you are aiming for 12A and 80G. But many institutions, we don't claim 12A and 80G, then this clause may not be required. But the first part is very important. If you are aiming for minority status, then it's a requirement that you need to specifically put a sentence in your objective stating that it is primarily for the benefit of so and so community.
As you said just now that from the society, majority should be from that community. I mean, number of student, whether the student should be predominantly from that community, or the school can admit the students from other communities as well. Because many states are raising this question. If the students are not from that particular community, then they are denying the certificate basis on that. Please explain.
Yes, very interesting, very relevant question. Yes, we are only on the first point. First point says about, the establishment and how to establish and what are the conditions are required. And then the question is related to the second aspect. Is there a requirement for admitting a certain percentage of minority community members for the purpose of getting minority status? That is what the question has actually raised. Here, as per the verdict of the Supreme Court, the word minority means what? The minority means less in number. So that is what the Supreme Court says. So as per the Supreme Court, you cannot say that you will grant minority certificate or the minority benefit can be availed only if you fulfill so and so percentage. That is what the Supreme Court has stated in TMA Pi case. But unfortunately, every state is demanding a certain percentage for the purpose of granting minority status certificate. The state of Telangana and Andhra Pradesh, they are demanding 30% of minority community admissions for the purpose of granting minority status. The state of Tamil Nadu is demanding 50% for the purpose of granting minority status. But there are other states, they don't demand any percentage as such, but they are not granting minority status certificate. So today's meeting, I would like to point out one important aspect to Anwar Sahib and all the leaders of our community, that even though we have a secular government in the states such as Kerala or Tamil Nadu, now in Karnataka, Telangana, Andhra Pradesh, obviously, we have a secular government here, but still, our people are unable to get minority status certificate from the state. It's very unfortunate. We need to depend upon the center for this aspect. So, what is the state government is imposing these kind of conditions, such as, this much of percentage is required. That is absolutely not correct. Even the central authority, such as the National Minority Commission, is not prescribing any percentage as such. So let us ensure that, we have a right to get the minority right from the state itself, and let us inform the actual position. Now, yesterday I was attending the similar set of programs. So they say that the officials are asking 15 to 20 lakhs for issuing a minority status certificate. How an institution can pay this much of money just for getting our minority right? It's a fundamental right, it's a constitutional right. So it's absolutely bad. So it may be happening at the initial level or the lower bureaucracy. Let us take up this matter and apprise the top authority, at least the chief minister or the educational minister or the educational secretary, saying that this is what the factual position. And we have done the same thing in the state of Kerala, and the state of Kerala is granting minority certificate without insisting any of these things. That also the effort of almost 15-20 years, we filed number of cases in the High Court of Kerala, and it is settled. This position is settled in the state of Kerala. Now it's not a problem there. Similarly, in the state of Tamil Nadu also, we have done, and there are certain guidelines were issued, but still, even though there are guidelines from the education ministry, the local level officers are still demanding. There the money is more. There it is 30 lakhs. They are asking this much of money for the purpose of granting minority status certificate. So my point is, one institution may not be able to take up these kind of matters, but we have an association. We have a powerful association. Let us take up that matter before the appropriate authority, so that let the competent authority may grant minority status certificate only on the basis of the minimum criteria as prescribed by the Constitution and also interpreted by the Supreme Court. So, what are the indicias for getting minority status certificate? So, we were already discussed that, the establishment, there has to be a society or a trust, and there has to be a specific clause, and the founding members of the trust and the governing body members of that society majority has to be from that minority community. So that is what the indicias for granting minority status certificate as per TMA Pi is 3. There are 3 indicias are required, or 3 criterias or 3 requirements are there for the purpose of obtaining minority status. One is, who established that institution? The establishment means obviously we have discussed, yeah, there is a society or a trust, and name alone is not sufficient. Name of the entity alone is not sufficient. Who originally established that trust? That means the founding trustees, their name. They are supposed to be from that minority community. And similarly, not only establishment, the present administration also has to be from that minority community. Present administration means the present board of trustees or the present governing body. They are also supposed to be from that minority community. So both establishment and administrations are very important. Here, please note that nowadays the minority communities may take over some of the institutions which are already established by other community. Suppose some majority community such as Hindu community established an institution, or other minority community such as a Christian institution is already there. Can we take over and can we claim the minority status certificate? Here there are two conflicting verdicts from different high courts. One high court Delhi High Court already stated that no, Constitution says that establishment and administration both are required. So you can only claim minority certificate if you establish an institution, and similarly if you are continuously administering it, then you can claim the minority certificate. Otherwise, if it is already established by a majority community, then you cannot claim the minority certificate. That is what the Delhi High Court verdict says. But Kerala High Court interpreted that even though an institution is established by a majority community, subsequently if a minority community is taking over of that institution, that again it's a kind of establishment or a re-establishment. So accordingly, they are entitled for minority status certificate. That is what a conflicting verdict that has come from the Kerala High Court. Now this matter is pending before the Supreme Court, and let us see. There may be a positive outcome in favor of the taking over of institution also. But as on today, the legal position is that for claiming minority status certificate, both indicias are required: establishment and also administration. Yeah.
There may be some minority institutions, because of their ignorance and all, they have not drafted the objectives which should share that they are established for the minority community. So now can they modify, though they are established by the minority community, but in the aims and objects it is not clarity there. So can they modify the aims and objects and claim the minority status?
Very important question. So there are two aspects as far as this question is concerned. Firstly, he started his question by saying that ignorance. By ignorant, it was not there. Please note that this Indian system, the Indian legal system is acting on a fundamental principle that ignorance of law is not an excuse. Somebody committed a crime, somebody killed another person and said, I was not aware that it's not a crime. Can he claim exemption? No. So Indian system functions on a fundamental principle that ignorance of law is not an excuse. So in any case, we cannot say that I was not aware, I was ignorant. Now POCSO cases, there are a lot of cases are filed against the institution saying that you did not report that matter to the police. Then we will discuss on POCSO Act specifically. So in those matters, generally even the lawyers and even the administrators say that we were not aware. So kindly grant us the exemption. So in all such matters, court says no, ignorance of law is not an excuse. So that is one point, one part of that question. But secondly, the question is very important, precisely saying that originally in the memorandum of association, if there is no specific clause, can you modify that? That is what the question. Yes, obviously you can modify that. You can, because the objectives of an association or a trust that is fully up to the governing body or the board of trustees of that institution. They can pass any objectives, they can modify it. Today the governing body took a decision that we are going to establish a medical college, or we are going to establish an orphanage. So whatever it may be, even if it is not there in that memorandum of association, no problem, we can add it. Similarly, the clauses, the relevant clause which are saying that primarily for the benefit of one, so even if it is not there originally in the memorandum of association, these clauses you can add it, and after that you can claim minority status certificate. But there are certain things you can modify. But the founding members are concerned, if the members are not originally from that minority community, you cannot change that, because founding members are obviously there at the time of founding or the establishment of that institution. That you cannot change. But the other things, such as if there is a clause is not there, definitely you can add it by way of a modification or an amendment or a supplementary deed. You can add it. Similarly, at the time of establishment itself, we should be clear about the purpose for which we are establishing a society or a trust. If you are establishing a society or a trust for the purpose of a childcare institution such as an orphanage or a destitute home, if that is not there in the objective, then later stage, you have moved an application here and there, and at a later stage, the authority can deny the application for recognition or permission, stating that your objectives doesn't say for what purpose you are established that particular society or a trust. So please note that we should be clear about the purpose for which we are establishing a society or a trust, and ensure that we are writing all such aspect in our trust deed or the memorandum of association. Nowadays I could see the memorandum of association which can say every objectives under the sun, everything they are mentioning. Yeah, so that's in one way it is good, but ensure that at the time of drafting itself we should read it, and let us ensure that what is the vision. We are doing all these things for a vision, and we have a mission also. So ensure that all the stages are very, very important. We need not left it to the person who is drafting, or a typist, or a lawyer, or an auditor who is doing all these things. Let us also ensure that we are adding all the necessary principles and necessary objectives at the time of originally drafting of that society and trust itself. These things are there. At the moment, people can add all these clauses by way of a supplementary deed, but there are court rulings stating that the original objectives by which an institution is established, you cannot modify it. There are such decisions also, but fortunately, as on today, for the purpose of minority thing, we can add it, and accordingly we can get the certificate. But it's a contentious issue. Because there are certain trust deeds and there are certain laws, especially in the state of Maharashtra and Gujarat, stating that there are certain aspects you cannot change. So always ensure that it's always a best practice that we are adding all the necessary thing at the original establishment itself, because the original establishment, especially the religion of the founding members, that cannot be changed. Objectives can be modified, but there also, if you say that we are going to establish secular institution for catering the need of all people irrespective of caste, creed, color, religion and sex, and subsequently you started a school, and after that you say that we want to make it as a minority institution, so there can be objections. So always ensure that at the initial time itself, let us be clear about the purpose for which we are establishing a society or a trust. The requirements for obtaining minority certificate we already described: establishment, administration and the beneficiary clause. There, as I told, there has to be a clause in the memorandum of association or the trust deed stating that it is primarily for the benefit of so and so, and for claiming the tax benefit, the other part also you can add, saying that exemptions are the benefits are also extended to others irrespective of caste, color, creed, religion and sex. And we have already described about the percentage aspect also. The Supreme Court says that you cannot prescribe a mandatory percentage as such, but here please note that you cannot deny admission to that students from that particular minority community. If you get minority status for the Muslim community, and then some eligible students are coming up, and then you cannot deny admissions. If you are denying admission, your minority status can be taken away, because what is the purpose behind the whole minority right? The minority right is for the empowerment of your own community. So after getting certificate, if you are not providing admission to your own community members, you are actually violating the principles. It's very wide and common that there are certain places.
Benefits of having this minority status.
Yes, we are proceeding to that.
And which is the competent authority to issue this minority status? The state government or the central government?
That also we will describe. That also we are going to that the other two stages.
They are having the recognition since more than 2 decades.
Minority certificate.
Not minority.
Recognition for the school. Yes.
And some of them even having the minority status certificate also,
Okay.
including me.
Okay.
This is a permanent one which was issued in the year 2004 by the state government.
Okay.
But so far what we have observed is we have not availed any sort of benefit for having this minority status certificate.
If
Okay.
it's not available, the rules set for majority community and minority community are just like the same.
Yes.
Okay.
So the question is, what benefit actually is this certificate for?
Okay.
Zenith school is having, Ahmed school is having, Hyderabad Mission school, and we have the minority state certificate, permanent certificate issued in the 2000 year by the state government.
Okay.
But so far we have not availed any sort of benefit.
No, actually,
That is because you don't know what kind of benefits are we entitled.
Exactly.
We should aware about what are the rights all about, and without knowing the benefits, and many you may be enjoying it also, but obviously it's not only getting some money or something from the government. Otherwise also, is RTE is applicable in your institution? Right to Education Act. Thanks to Anwar Sahib for actually conducting these kind of things, so that we could meet and we could see what are the rights and where are the minority rights can be useful, and where are there are many instances wherein, as I told, if a POXO case come, there are institutions saying that ours is a minority institution, we are exempted. Is that actually exempted? So these are the aspect we need more clarity. So the first aspect of the presentation is almost over. Now let us proceed with the questions as rightly came up from here. One is, yes, please.
When you are establishing a society as a Muslim minority society, so already we have, then why do we need a minority status also?
Yes, very important question. Yeah, you are saying that already it is established by minority community, and there is a clause also in the objective stating that it is for the minority community, but that is a self-proclamation from your side. Is a self-proclamation is sufficient or not?
But it's registered by the Societies Act.
Yes. It's not only a self-proclamation, you are saying that there is a registration also. But is that eligible to declare it as a minority institution? That is what the question. There are not only yesterday also I was actually having a session by which there are some diocese means Christians are concerned, there are certain religious setup. So the diocesan and the religious nuns and the fathers, it's a non-minority community, so they themselves proclaim as a minority community, and they are saying that it's a minority institution, as you rightly pointed out. But that self-proclamation is not sufficient. You raised a very valid point that there is a registration also from the registrar, but registration, yes, but the registration is your registration is, it may be as a trust or a society, not as a minority institution. There is no such registration for minority institution. If some set of registration is there for a minority class, a separate thing, then that may be sufficient. But as on today, the registration is a common thing. Anyone can go and register a trust or a society. But that doesn't say that it's a minority trust or a Hindu trust. Nothing is there. Nothing is there, or nothing is visible by merely looking at that a trust or a society. So, self-proclamation or a mere registration from the registrar of society or a sub-registrar office is not sufficient, because the government can rightly put an objection that if you say that you are a minority, what is the proof? Where is the proof? There has to be some proof to the effect that it's a minority institution. So, the minority certificate which we are talking is the conclusive proof stating that so and so institution is a minority institution. So it's a legal document, it's a legally certified document, and the question is, which all are the authorities for issuing such a document, minority status certificate. So certificate is very important. It has to be from any competent authority. Apart from the registration from a registrar of society, a minority status certification has to happen from, there are two main authorities by which you can claim the minority status certificate. One is concerned state government is the first authority to grant minority status. They can declare your institution as a minority. For that purpose, all the indicias, whatever we have described, that the government can verify all these things, saying that who they established by whom, it is administered by whom, and who all are the beneficiaries. They will see, okay, how many trustees are there from that community and how many admissions are there, what are the staffs are from majority or from which community. All those things they will verify it, and accordingly they can certify that on the basis of all the required documents we are satisfied and we are issuing minority status certificate. Such an order, the state is the first authority to grant such a certificate. As our Leonard brother told, he obtained a certificate from the state government. Even I could see a lot of such order from state of Telangana and erstwhile Andhra Pradesh. I could see a lot of such certification. There was a habit of issuing such a certificate earlier. One of the defect which I noted with such certificate was that they may be saying that this certificate is valid only for 1 academic year or 2 academic years or 5 academic years. That is what one of the demerit of the certificate which are issued from the state government. On this aspect, there is a judgment specifically from the Madras High Court stating that minority status certificate is not like a driving license. So it should not be renewed periodically until and unless there is a change in the management. If there is a change in management, that's a different question. But otherwise, as long as the management continues, you cannot issue certificate for 1 year or 2 years, 3 years, 5 years like that. There is a reason for issuing such a certificate.
As you said, the state government is also competent to issue the minority status certificate, as well as the central government is also. But in state government, there are 3 departments. One is the head of the department. I mean, whether it is director school education or director higher education. The other authority is minority welfare, Department of Minority Welfare. The third authority here is there are many states where the commission for minorities are also there. So in our state also we have. So in the rules also there is a statement that the state minority commission can also issue the minority status certificate. So now the question is, in state also there are 3 authorities. So what you say on this?
I have studied this matter very thoroughly. Please note that in the state of Telangana, you are talking about state of Telangana, right? State of Telangana, there is only one authority duly competent to issue minority status. That is the Government Department of Minority Welfare. That is the authority to issue minority status. There is a state minority commission, but they are not the legal authority to issue minority certificate. They may be giving simple certificate saying that, yeah, they are minority, but that is good for nothing. Or that certificate you can use it for producing it before the competent authority such as the Minority Welfare Department. Minority Welfare Department is the competent authority as notified by the state of Telangana and state of Andhra Pradesh. In both states, the Minority Welfare Department, that's a government department. And a joint secretary, an IAS officer, is the one who is generally acting as the secretary, and he is the competent authority to grant minority status. Here the question is, they are insisting for percentage, they are insisting for caste certificate of all the governing body members who founded the institution and the present governing body, all such things they are insisting. So that we may not be able to get those caste certificate of the founding members and the present governing body. That may be literally very difficult.
They are asking the data of students for past 5 years.
Yes, that we may be able to fulfill, because as Muslim minority community we may be having sizable number of population in many of our institutions except few areas. But the other minority communities are literally having that difficulty, because the minorities such as Buddhist or Sikh or even Christian may be there, but 25% of admission virtually impossible for them. Even Muslim minority community, there are certain areas, even they don't have 25%. So this percentage is actually a major concern. That is the reason why we are unable to get these certificates from the state government. And moreover, they are also demanding huge money. The corruption is there in all these. Absolutely no. There is no such percentage as such, but they will consider naturally. An authority can see all these things. We are actually saying that, yeah, it's a minority institution. Minority institution means what? Minority institution means we are there to empower our community. How the empowerment is happening? Empowerment is happening by giving job to our own people, by giving admission to our own people. That is how we are empowering our community. But again, the other question is, yeah, what are the advantages? What are the rights? The TMAPI case very specifically says that there is no such mandatory requirement that you should hire only the people from your own community as the staff or the head of the institution. That is totally up to the management to decide who has to be the head of the institution. That choice is there. You can have anybody. The management has a vision as far as their institution is concerned, how it has to be, what the outlook of that institution, and there are certain vision for every management. So the staff and the head of the institutions are very important to fulfill the vision of the management. So you are free to appoint anybody. That is what one of the major advantage as far as the minority right is concerned. So rightly said, you have minority certificate. Then what are the rights for us? That is what the other question has actually came up. So one of the right of minority status certificate is that you can appoint anybody as per your choice, provided that they should have required qualification. You cannot have a 10th failed man as the teacher. That you cannot do. State is prescribing certain qualification for every post, for non-teaching staff or teaching staff or the head of the institution, the state government or the affiliating body. If it is a college, then that affiliating body, they have their own norms. So they may prescribe their guidelines and norms and criteria. You need to follow that. You cannot say that I am a minority, so I will appoint so and so as the head of the institution. No, that cannot be. Whatever is the norms and criteria, especially the educational qualification, along with the other experience for discharging the position as the head of the institution, not only the academic qualification, there are certain experience also may be there. So whatever is the qualification prescribed by the appropriate authority, we need to fulfill that. We need to follow that. If the qualifications are there, then it is up to us. We can appoint anybody. That is what one of the major right as far as the minority right under Article 30 is concerned, as settled by TMA-5. Here also please note that the head of the institution, the appointment of head of the institution on a normal institution, naturally the senior most will be appointed as the head of the institution. That is what the norm applicable for all the general institutions. But that is also not applicable for a minority institution. You need not follow the seniority.
Rule of reservation.
Yeah, we are coming one by one. Yeah, as far as the head of the institution is concerned, seniority is not applicable. You need not follow the seniority because other institutions are concerned. Yeah, naturally the senior most is eligible to be appointed as the head of the institution, especially if it is an aided institution. It's a hotly contested matter because aided institution, somebody worked for 15 years, 20 years, 25 years, and by getting that appointment of the principal or the whatever is the head of that institution, naturally they are entitled for more benefit. So if the management is not appointing the senior most and appointing another person, then there are chances for court cases. But the Supreme Court has rightly pointed out that if it is a minority institution, there is no seniority law is applicable. It is up to the management to decide and appoint anybody as per their choice. That is what one of the major right as far as minority right is concerned. And secondly, sir rightly pointed out that whether the reservation is applicable on a minority institution. Answer is absolutely no. In all the general institutions, there are reservations, both for the appointment of teaching and non-teaching staff, and also for the admission criteria. There are reservations in our country. That is the law. Reservation is applicable in all these aspects. But if it is a minority institution, reservation is not applicable as per Article 15, subclause 5 of the Indian Constitution. That is another right. And thirdly, how to admit students. The TMA-5 case saying that or settle that right to admit students, that is again it's part and parcel of minority right. You can admit students as per your choice. But here also please note that you have a right to admit students. That doesn't mean that you can pick and choose from here and there. That is not permissible. There has to be some guidelines. Merit has to be the criteria. If there are 100 students from the very same minority community and the total seats are 50, then you cannot pick here and there. There has to be some norm and some reasonable structure. Normally, merit is the criteria. If you are violating merit, then the court can interfere in your minority right. So generally, the right to admission is one of the part and parcel of minority right. But ensure that you are not violating the principles of merit. You cannot pick and choose. That is another aspect. And then, minority institution can have a reasonable fee structure. That is again one of the major right as part of Article 30. You can fix a reasonable fee structure. That is what the word used by the Supreme Court. If you are a minority institution, you cannot fix any fee as per your whims and fancies. No, you can fix a reasonable fee structure. So now in every state there are fee regulation committee. Fee regulation committee will scrutinize whatever the fee fixed by the government is correct or not, or reasonable or not. There also, minority institution they are actually classified on a higher pedestal. Especially in state of Tamil Nadu and here also, minority institution that is on a different slab. So you can raise a little more fees you can, not like other institutions. So that is actually, yes.
they are supposed to follow the academic calendar issued by the state government, or they can prepare their own.
Please note that minority shed certificate is only for the purpose of the rights which are settled by the Supreme Court in TMA Pi Foundation case. That doesn't allow you to prescribe your own curriculum or your own the academic calendar and the schedule. That cannot be, because your institution may be recognized or affiliated by an affiliating body. So whatever is the guidelines they are issued by the affiliating body, we need to follow that. But there are certain things. If you are on a special day, if you declare as a holiday, then you can compensate by.
Already the Christian missionaries, they used to give the holidays in the last week of December.
Yes.
Yeah, but we, the Muslim minorities, they're reluctant to give this type of holidays during our festivals.
Yes. It's very important question. There the only question, the Act says that on an academic year, you should have a minimum number of academic days such as this. So if you are fulfilling that by you declare a holiday on so and so date and then compensating with another day, that is permissible.
We are not permitting to do so.
Absolutely, that may not be. We are actually in a secular country, so there are certain areas it is not negotiable. There are some of our rights that is non-negotiable, but there are some of things, wherever it can be accommodated, let us not create any controversy as such. Certain things, whatever is our right, if we want to enforce it, we need to enforce it. If tomorrow the state government says that we will send teaching staff from our side, that is actually violating your right. You cannot permit that. Similarly, at students, if they are sending their own quota to you, that is what the whole issue related to Right to Education Act. It is applicable everywhere. It is there, but your institution, that concern may not be there. But Right to Education Act is a major concern. States like Delhi, Maharashtra, or even Bangalore, if it is a good, excellent institution, then the RTE admission is a huge concern. If your total admissions are actually 100, then RTE Act says that 25% of the admissions are reserved for EWS. So the EWS admissions are controlled by the state. You have no say. So that's a major concern for the institutions in our country. So that is one of the major reasons that people are trying for minority status. If you have minority status certificate, then no RTE Act is applicable to you. Yes, that is what the major.
This is one of the major benefits. Apart from this, which are the other major?
That is what we discussed. We are only concerned with the benefits. That is what the another thing. RTI is Right to Information Act. The RTI, no. Right to Education Act, Right to Free and Compulsory Education Act, RTE, Right to Education Act is concerned, we are exempted. In Pramadi Educational and Cultural Trust versus Union of India, the Supreme Court has stated that as per Section 12C of RTE Act, the government sends 25% of admission to any institution. So that actually violates the right to admission as settled by TMA Pi Foundation case. And the Supreme Court held that minority institutions are exempted from all provisions of Right to Education Act. Let us see it as the whole act. Otherwise, RTE, it's always confusing. Right to Education Act, RTE Act, that is not applicable for minority institutions. So we need not follow the 25% of admission quota sent by the state. That is what most important thing, because once you gave admission under RTE, that students will continue till 8th standard. As on today, it is till 8th standard, but now we are on the verge of new education policy. New education policy says that the free education and it will continue till 12th standard. So then, once you give an admission under RTE quota, they will continue up to 12th standard. So 25% of your admission is not a small number. So general institutions are actually struggling to cope up by having this 25% from the government. So that is what one of the area where institutions are struggling. So fortunately, we minority institutions are actually protected from implications of RTE Act. 25% is one of the major area. There are so many other things. There are issues such as School Management Committee, SMC. SMC is actually that's a concept by which the locals are also having a say as far as the administration of the institutions are concerned. School management committee will naturally have the PTA president or the local representative or such people. So there are places like Madhya Pradesh or Uttar Pradesh. They say that you should install Saraswati in your institution because these are certain communities are dominated there. So they may be saying that yes, as far as we are concerned, that is a goddess of knowledge. So why don't you put that? The local SMC may say like that, but a minority institution may be having certain apprehension on getting or acceding such kind of recommendation. So these the school management committee and their recommendation, all such things are not applicable for minority institutions. So that is what the major advantage. Generally, there may be a perception among the minority community that whether the present dispensation is going to take away the whole minority right, whether the Article 30 right, the educational rights of minorities, can it be taken away by the present dispensation by way of amending the whole constitution? Such a concern is there among many of our minority communities. So now, along with that thought process, there is a new education policy has also come up, and in the new education policy also there is no term or nothing is mentioned about the minority right or anything as such. So naturally, people may be thinking that something is on the pipeline. Will that affect us? So that is what the general concern. So friends, please note that legally speaking, there is no such there is no place for such a concern. It is due to the reason that even though the present dispensation may be thinking that they are not happy with the minority right, because the majority people, those who administer, those who govern us, they are really not happy with the minority right, but legally they cannot take away the minority right. It is due to the reason that in the year 1972 there was a landmark judgment passed by the Honorable Supreme Court of India known as Keshavananda Bharati versus State of Kerala. That is one of the landmark judgment passed by the Supreme Court of India, and the largest bench also was constituted in Keshavananda Bharati. 13 judges of the Supreme Court judges sat together and passed the Keshavananda Bharati judgment. In the Keshavananda Bharati judgment, the Supreme Court has considered the issue regarding the capacity of a government to amend the constitution. The Supreme Court has considered in detail whether a government, whoever is in power, can they amend the constitution? If yes, how much can they amend? That is what the question considered by the Supreme Court. So in the Keshavananda Bharati case, the Supreme Court stated that constitution can be amended, but the basic structure of the constitution cannot be amended. So then again the question has actually came up. What are the basic structure or the basic feature? So in subsequent decision, Supreme Court clarified that the basic rights such as the basic structure or the fundamental principles such as the fundamental rights guaranteed under in the constitution, or the parliamentary form of democracy, or the separation of power in the judicial system, and the independence of judiciary, all these things are part and parcel of the basic structure, and hence it cannot be amended. Earlier someone was asking about the constitutional validity of Right to Education Act. So I have already described that in the year 2013, the Supreme Court of India, by way of a constitution bench judgment, clarified that Right to Education Act is not applicable to minority institution. And in that very same judgment, again the Supreme Court clarified that minority rights are part and parcel of basic right, and hence the basic right or the basic structure that cannot be amended. So fortunately we are safe due to the interference of our judicial system. So friends, please note that there is no place for an apprehension that whether this government or any other government in future, will they take away the minority right. There is no such place for such an apprehension, because everybody may be thinking due to the present treatment which minorities are getting at some places. Due to that, generally people may be thinking that will they take away the minority right, even though again I am telling the present people are not at all happy with the minority right, but legally they are powerless, nothing can be done. So fortunately, we are safe with the landmark judgment of the Supreme Court. So the other aspect is related to new education policy. Friends, please note that in the new education policy is a visionary document. Prior to the 2020 education policy, there was a education policy which was there that was there passed in 1986. That is redundant. So timely, every government or depending upon the changes happening in the world, there has to be a timely change in the education system. So new education policy was the need of the hour, no doubt. But that is nothing to do with the minority right. Educational rights guaranteed for the minorities will continue. Whether they say anything in the new education policy, that is immaterial. Education policy is only saying about the restructuring of the institution and the higher education, how it would be. So that is nothing to do with the minority right. So even if there is no specific word related to the minority communities, we need not worry. But please note that there is nothing against us in the new education policy. There is no word against the minority community or minority rights. So we need not worry on the aspect of new education policy also. So what actually I would request you is to let us be clear about what exactly the minority rights, and let us also exercise our minority rights in the correct perspective. Because there are certain areas, there are certain rights. But there are many areas there is no separate right as such. Nothing is there for a minority community, especially related to Right to Information Act. There are institutions which may receive a lot of questions related to RTI. So there are institutions giving a reply saying that ours is a minority institution, so we will not give any reply to you. We cannot say such a stand. We cannot take such a position. That is nothing to do with the minority right. Similarly, a POXO case is reported, or some employee has committed some mistake or some kind of thing. So there are certain areas we are bound to follow the rule of the land. There is no separate right, especially for minority right or minority community. But there are certain areas we have minority right. As I told, TMAPI has clarified these 4 important heads of minority right, which related to right to appoint teaching and non-teaching staff, right to fix a reasonable fee structure, right to admit students, and right to take disciplinary action against the delinquent employees, and then right to have your own governing body. These are the major rights granted to a minority institution, explained by the TMAPI case. That is also again an 11-judge bench of the Supreme Court only categorically dealt about the minority rights, and whatever is the rights which are already declared by the Supreme Court by explaining Article 30, those are our right. So especially on the management of institution, yeah, definitely. Right to Education Act is not applicable to minority institutions. Similarly, the appointment, the seniority law, already we have explained. Seniority, even among a minority person is eligible to be appointed. Even we can remove that person and we can appoint a non-minority community. Because right to appoint anybody as the head of the institution is part and parcel of minority right. So coming back to the Right to Information Act, RTA Act, again there is a concern. Which all are the institutions covered under RTI, and which are the areas wherein we need to give a reply? Please note that Right to Information Act is definitely a powerful legislation enacted by the Parliament, which mandates that all the governmental agencies are covered under Right to Information Act. Governmental authorities means both center and state governments. We have 2 types of government, and all the governmental authorities both under the center and the state are covered under the RTI. So as a citizen we can apply for an information from them, and they are duty bound to issue information to us. Now the question is, we are all having society and trust. These are non-governmental organizations. So whether non-governmental organizations are covered under the purview of Right to Information Act, that is what the question. So again, the RTI Act 2005 specifically says that if a non-governmental organization is receiving grant from the government, then whatever is the grant which you receive from the government, to that extent your institution is bound to provide information under RTI Act. So otherwise, absolutely you are not. It's a private entity. It's a private institution. If it is an unaided institution, you are absolutely not covered under RTI.
Public funds are not involved.
Absolutely. So largely we may be having aided and unaided school. So aided schools, if you receive some benefit from the government, so related to that, if some question come, you need to give an answer. But otherwise, questions may be related to the administration of the institution. Even if it is an aided institution, you need not give any reply. But please note that if you receive such an RTI application, you need to respond. You cannot simply keep mum. That is not the way. You should give a reply to the effect that our institution is a unaided institution or a private institution. So this is not covered under section 2H of the RTI Act as a public authority. So we are not liable to disclose any information. That is what the reply we should give. Again, I could say that we should say that the so and so institution is a private institution, and this institution is not covered as a public information office covered under section 2H of the 2H of the RTI Act. That is how we should write, and we should send a reply. Reply is mandatory. And secondly, many a times you may be receiving direct question from the RTI application. Direct question you may receive. Many a times you may receive application maybe from the Mandal Educational Office or any other office. People may, they know, the citizens are fully aware. They know that, NGOs are not covered, or societies and trust, even if they are applying, they will not get it. But what they will do? They will give an application to the Mandal any governmental office, because we are covered under the government, under the education department. So many information we are supplying to the government, to the educational officer or the education department, or to the local self-governments we are supplying. So people may ask information from them. So whatever information which they have, they could provide it. But what they will do? They will forward that application to us. That is a mandatory requirement, because if a question comes to any authority, if they don't have that information with them, they should send that application to the appropriate person. So they are, the Mandal Educational Officer or whoever is sending an application to you, they are doing their duty. But that doesn't mean that we should give reply. Even if we get a even if we receive a letter from the Mandal Educational Officer, the same thing we could say. As per section 2H, it's not a public authority, so we are not liable to give any information. So that is what the reply we should give. They cannot force you. Now, even if, suppose if you are an aided school, even if you are not giving information, what the Act says, they need to file an appeal. If you are not giving any information, Act says that they can file an appeal, first appeal to the first appellate authority. Even if they are not getting, they can file an appeal to the Information Commission. Nothing more. There is nothing can be, so there is no place for any pressure as such. That may be they are doing the pressure because they may be getting some money, or they may be having some other thing. So ensure that you are not bound by the RTI. If we are not sure, if we are not aware about the RTI and section 2H, then definitely they may be putting pressure. Otherwise, it's a straight matter. We could say that this is a private authority. We are not covered under RTI Act. That is, there are enough judgment from the Supreme Court and Information Commission on this aspect. Schools are private bodies. They need not provide any information. So we should apply, and we should tell them properly. Now, many people are also, wherever, yes, absolutely. These positions are very well settled. There are enough judgments. You need to only supply that information to the concerned people, because many a times they are also not properly aware about all these aspects. It is our duty to inform them. Now, even if we are running minority institution, we are not sure about many aspects. There are reasons, because it is not properly described or codified in any of the legislation. There are judgments. Even the lawyers are unable to interpret all these things properly. So ordinary people are concerned. It's quite natural that there are concerns. So it is our duty to ensure that, we know all these aspects, and we should be equipped, so that we could handle all these people. We could say there are certain officers may say, minority institution means what? You need to follow all the laws. They may be saying like that. Then we need to clarify them. Sir, this is not the position. See, it's a minority institution, so all these things are concerned. Right to appointment. It is our right. So we need to educate them, because they are coming from a normal background. They may not be having any legal standing or anything as such. Similarly, RTI, for them, all institutions are covered. That is what their basic understanding. So we need to educate them with proper documents, with proper information. So that information is the key. We know that we are living in a time where lot of issues. running institutions was actually a great job or a great occupation or a great service to the nation while we consider during the earlier days. But now things are changing. Time is, it's very difficult to run an institution. But if we have proper information, proper awareness, and we need to follow a number of laws. Nowadays, actually, all the head of the institutions are actually sitting on a time bomb, because every individual is having, every students can file a complaint by merely dialing some helpline number. They can simply register a complaint to the Child Welfare Committee at the local level or the state level or even at the central level. Merely dialing one helpline number, they can register a complaint. So we are actually, then we need to go behind that. So let us be aware about all the legislation, including RTI, as I told. Similarly, POXO Act. Yeah, POXO Act, we need to conduct proper awareness among our staff. And mandatory reporting is a very important aspect. Mandatory reporting as per section 21 says that if any sexual harassment is reported in your institution, you have a duty to mandatorily report that information to the local police. Even very recently, there is a case reported from state of Haryana. That institution was there in Faridabad. It's a non-institution. What was the mistake of that? The principal of that institution was that a child and the mother of that child sent an email to the institution saying that the colleagues of that child is sexually assaulting and sexually harassing this child. Kindly take some action. There was an email 2 years back. And the institution also conducted some kind of inquiry and some kind of counseling within their institution, and they found out that nothing major, and accordingly they closed the matter. But after a gap of 2 years, that child committed suicide by saying that so and so children insulted and harassed, and accordingly on that basis the child committed suicide. And then this whole incident, whole episode was again came to the limelight. Then the question was whether the principal has performed the duty correctly or not. The principal stated that, yeah, I received an email from the mother and we have done the enough thing. We have reported that matter among our school authorities and there was some inquiry and we have done the necessary thing. That is what the stand taken by the HM of that institution. But the High Court decided against that principle, saying that you have a mandatory duty to report the matter to the local police. You did not report that matter under section 21. So please note that 21 is very important. If any kind of sexual violence or sexual harassment is reported in our institution, conducting a domestic inquiry, all those things are fine. Even if you are not doing that, that's not the concern. Are you reporting that matter to the local police or not? That is what the concern. So let us be aware about all these kind of legislation. What are the checklists? What are the mandatory things we should follow? Let us be aware about all such things so that we may be able to run our institution properly, and ultimately we will be at peace. Now another aspect is corporal punishment. Corporal punishment, even I came from a circumstances where I used to get a lot of beatings and pinch from my teachers. And even if I was actually under fear to say that aspect to my parents, because if I say that aspect to the parents, then I will get again from parents also. We actually came up from such a background. But please note that time has changed. What the law says, corporal punishment is not permitted. Right to Education Act is specifically saying that corporal punishment is it's banned. It's not permitted. Not only Right to Education Act, Juvenile Justice Act 2015, there is a specific section stating that all forms of corporal punishment, not only beatings or any such nature of punishment. Corporal punishment is fully defined in Juvenile Justice Act. So if you are applying any kind of corporal punishment, then it's a punishable offence. So these are not permitted. So we may be having certain individual perception, because still we may be thinking that some kind of punishment with best interest of the child, just to guide or make them proper. Some kind of punishment may be permissible. Still the teachers and the parents may be having that thing in their mindset, but our law doesn't permit that.
The teacher doing this corporal, do the management has a mandatory law? Do we have to inform it to the police for corporal punishment?
Corporal punishment, you need not inform to the police. That is not mandatory thing. what the act says is, first of all, corporal punishment is not permitted. Secondly, if the corporal punishment is committed by any of the staff, then you need to conduct an inquiry, domestic inquiry, and depending upon the situation, you can take departmental action against the teacher. But if there are certain instances wherein there is a fracture on the hand, in such a serious situation, definitely you should report it to that local police, because depending if it is a crime, it's a grievous aspect, then definitely you need to report it to the local police. But otherwise, for the minor things, you need not report to the police as such. But yes, definitely some warning or show cause notice to that effect is required to be issued to the concerned teacher. But any instances of sexual harassment, whatever issues are covered under the POXO Act, that definitely you should report it to the police.
Sexual offenses.
Yes. The POXO Act, yes, yeah, Protection of Children from Sexual Offences Act 2012. That is what POXO Act. So any incident, any offences defined under POXO Act, definitely you have a mandatory duty to report it to the police. There are many instances wherein false cases are reporting. Many cases may be false, but we are not the authority to say that whether it is true or false. We have no mandate. Our duty is to report. Let the police say that it is a false complaint. But if we are not reporting, we are committing an offence. That's the thing. Mandatory reporting is a non-negotiable principle. Yes.
The disclosure of information.
Yes.
That private schools, because the public funding is not involved. But now the department is insisting on disclosure.
I think there are so many people in the virtual mode. Can they hear it? So if the mic can be used. Now anyway, it's open for all. Let us have a question answer session. Yeah. So please use mic, and so that and somebody can even read the question in the chat box, so that any questions are there from the virtual participants, please put it in your chat box so that we could address your concerns. Yeah.
What I'm saying is, these days the government authorities are insisting private schools to disclose the information in the website in public domain. For example, fee structure, school governing body, parent teacher association, all this information, even infrastructural facilities also. So do they come under RTI, or minority institutions are exempted? Can they say that they cannot disclose this? So this is what I'm asking.
Very important question. This question is nothing to do with Right to Information Act. The mandate of the respective state education laws or the affiliating bodies such as CBSE, stating that every institution has to have a mandatory website. And in that website, there are mandatory things. You should disclose all those information, your affiliation number or the recognition number, your fee structure, your infrastructure, all such things, so that the parents can take an informed decision whether to send that child to that particular institution or not. So this is nothing to do with Right to Information Act, since we are actually governed under some laws. All the schools, where even if they are minority, the institutions are governed under the state respective state education laws. If the school is affiliated to CBSE, we are coming under the bylaws of the CBSE or ICSE. So that says about certain requirements. We need to follow that. So uploading all the relevant information in the website, it's a mandatory thing. That is nothing to do with RTI. If we receive any question under RTI as being a private institution, we need not provide any information, but we should give a reply stating that this is not a public information, a public office as per section 2H.
Do we have extra exemptions if a society is established by women, minority women?
Minority rights are concerned, there is no separate exemption for the women or men as such. There is nothing as such. But please note that there are certain government funding by Ministry of Justice, and there are certain state ministries and the center. So there are certain rights, certain exemption for the women empowerment. So if you are coming under any of those area, definitely you can get some benefit. But minority rights under Article 30 is concerned, there is no specific exemption for men or women. There is nothing as such.
सर, मैं आपसे एक गुजारिश करना चाहूँगा. बहुत सारे लोग आज अभी हमारी मीटिंग में नहीं हैं, तो जितने अभी एग्जम्पशंस आपने बताए हैं वो सारे के सारे जो है ना आर्टिकल 30 के तहत माइनॉरिटी एग्जम्पशंस के, तो इसको अगर हम एक बुकलेट टाइप में क्या बोलना चाहिए MS के थ्रू अगर हम बनवा कर सारे जितने माइनॉरिटी मैनेजमेंट्स हैं उनको अगर हम जो है दे दें, और साथ ही साथ जो भी हमारे क्या बोलना चाहिए एडवोकेट्स हैं माइनॉरिटी के जो केसेस देखते हैं, उनके नंबर आज भी उसके अंदर डाल दें, तो जहाँ कहीं भी कुछ ऐसे प्रॉब्लम्स क्रिएट होते हैं डिपार्टमेंट की तरफ से, तो वो लोग इमीडिएट एक्शन में आते हुए एडवोकेट से कांटेक्ट भी करेंगे, और साथ ही साथ जो है ना उसके अंदर जितने बाईलास हैं यानी जो भी लॉस हैं वो पढ़ते हुए यानी आने वालों को वो जवाब दे सकेंगे। तो मेरी गुजारिश है अगर ऐसा हो सकता है तो एक बहुत बड़ा अच्छा काम होगा।
बहुत बड़ा सजेशन आ गया हमारा भाई साहब की तरफ से। हाँ मुसन साहब, ये बहुत बड़ा सजेशन है। इसका जवाब मेरे हिसाब से हमारा एसोसिएशन का जो ऑफिस बेयरर्स आपको दे देंगे। हमको अच्छा एसोसिएशन होना चाहिए, अच्छा हमारा एसोसिएशन में अच्छा वकील लोग भी होना चाहिए, क्योंकि इसके जो ये कानून के एग्जामिशन के बारे में सारा लोगों को मालूम नहीं है। नॉर्मल वकील लोगों को भी इसके बारे में मालूम नहीं है, जजेस को भी मालूम नहीं है, उसको हम सिखाना पड़ता है। और हमारा जो एजुकेशनल ऑफिसर्स है उसको भी मालूम नहीं है, उनके हिसाब से सारे एक ही जैसा है। आरटीआई का फ़र्क उनको मालूम नहीं है, माइनॉरिटी का आरटीई का उसको मालूम नहीं है। आरटीआई का किताब आप देखेगा तो उसमें ऐसा अभी भी उसमें ऐसे लिखा है ये कानून सबके ऊपर लागू है। हम उसको सिखाना पड़ता है। 2013 में सुप्रीम कोर्ट का एक ऑर्डर है, उसमें ऐसा एग्जेम्प्टेड है, इसलिए आरटीई एक्ट हमारे ऊपर लागू नहीं है। क्योंकि बहुत सारा माइनॉरिटी इंस्टीट्यूशन को उनको मालूम नहीं है, वो कानून वैसे देखता है। आरटीई एक्ट में अभी भी ऐसा लिखा है ये एक्ट सारा स्कूलों में लागू है, ऐसा है कानून में। हम उनको सिखाने का एक काम हमको है, इसलिए पहले हम एम्पावर्ड होना चाहिए, उसके लिए हमको अच्छा किताब होना चाहिए। मेरा भी 2 बुक्स इसमें एक जज साहब के साथ भी अभी लास्ट ईयर एक पब्लिश हुआ है, हम उसका डिटेल्स आपको दे देता हूँ। हम इधर हमारे एसोसिएशन के तरफ उसमें थोड़ा मॉडिफाई करके हमको जो जरूरी जो चीज़ चाहिए वो लिखे, ठीक वो किताब भी सर्कुलेट होना चाहिए, बीच बीच में ऐसा प्रोग्राम भी कंडक्ट करना चाहिए। तभी हमको ये हम बहुत मुश्किल टाइम में हम जो माइनॉरिटी इंस्टीट्यूशंस आर एक्चुअली बिल्कुल हमको ये पार करने के लिए हमको अच्छा जानकारी, लीगल सपोर्ट हमको होना चाहिए। लीगल सपोर्ट है तो हमको आसानी से जा सकता है। एसोसिएशन जरूर आपको मदद करेंगे। एसोसिएशन को जो भी सपोर्ट चाहिए हमारे साइड से बिल्कुल वो सारा प्रोवाइड करेंगे।
क्योंकि इतनी बड़ी शख्सियत आपके साथ में जुड़ी है, तो तमाम यहाँ पर जो है ना माइनॉरिटीज़ की फ़िक्र रखने वाले लोग यहाँ मौजूद हैं, तो उस एतबार से अगर इसको एक बहुत बेहतरीन एक बुकलेट टाइप में जो रिक्वायरमेंट है, जो ज़रूरी है, उस हिसाब से अगर वो बुकलेट तैयार की जाए और सारे जितने मैनेजमेंट्स हैं माइनॉरिटी मैनेजमेंट्स उनको दी जाए, तो वो लोग वो पढ़कर जो है ना अपने आप को परफेक्ट भी करेंगे। क्योंकि रिसेंटली मैं एक स्कूल के केस में एक पीएस गया था सर, तो वहाँ पर जैसे ही मैं गया तो सर्कल से बात किया, तो सर्कल ने ये कहा कि भाई आपको आरटीआई एक्ट मालूम है क्या। तो बहरहाल इस तरह वो लोग जो है ना सवालात करे, तो जो मैनेजमेंट जो स्कूल केस में था उनको कुछ नहीं मालूम था। तो मैं वहाँ पर जो है ना बहुत सारे जो है ना उनसे बहस किया, मैंने बहुत सारी चीज़ें बताई करी, तो फिर उसके बाद कंप्रोमाइज़ में बात हुई करी। तो इस तरह हर स्कूल यानी हर क्या बोलना चाहिए, जितने माइनॉरिटी स्कूल्स चल रहे हैं उनको अवेयर होना चाहिए कि क्या क्या चीज़ें हमारे को सीखना ज़रूरी है। तो इसके हिसाब से मैं आपसे गुजारिश करता हूं कि ये इस पर जो है आप।
Simple question is there. After the election of the 24, if it is going to be declared maybe at the Hindu Rashtra, so what is the role of the minorities then? What are the powers of the minorities then?
First of all, it's an assumption, or there are 2 things. One is what is going to happen in 2024, whether this dispensation will continue or no. That's an assumed question. That is one thing. Secondly, these are all hypothetical question. Hindu Rashtra, we don't know what is Hindu Rashtra. This cannot be, because we have a constitution, and as I told, the Keshavananda Bharati judgment is very clear on this aspect. The basic structure, that the preamble of the constitution very specifically says that it's a secular state. So can it be taken away? Can it be taken away? The preamble is part of basic structure. That cannot be taken away. These kind of things are coming out from here and there. We will change the minority rights, we will change the constitution, or we will change the whole thing into a different thing. It is not happened so far. If that was required now, at this time also they have a clear majority. They are not doing it because that cannot survive. And please note that ours is a great nation, no doubt. If any such things are happening, immediately the government will be thrown out by the Supreme Court, or our people are so matured enough. We are actually in a great nation. Now, people are thinking that, yeah, there are some development. Yeah, with that thinking only, the government is having still support from the common man. Thinking that, yeah, some development may be happening, and that is how they are still continuing. The moment they are going into this kind of communal thing, this country cannot survive, and definitely such a ideology will not survive. So there is, according to me, there is no place for such an apprehension.
What is the exact procedure for obtaining minority status from the central government, that is NCMEI?
Yes.
How much time it will take, and how much expenses will occur?
Yes.
Anything is to be done in the state level. That means we have to obtain or apply for a status in the state level for that.
Yes, I got the question. So as I told, for obtaining minority status certificate, there are two authorities to get it. For a minority status certificate, we can either get it from the state or from the center. From the state, earlier few people got the certificate, but nowadays still people are getting it, but they are demanding such a huge money. So that is one of the major concern which prevents our people from getting the minority status certificate from the state. And for making it so huge amount, they are also adding a lot of requirements. There are a lot of requirements that is nothing to do with the minority right. So fortunately, what our people, MS institutions and the others are actually doing nowadays is they are getting it from the center. Even though the center is actually coming under the present dispensation, but still the minority commission is not affected by the present dispensation, because there are laws. The Supreme Court has passed all these requirements, so they cannot add anything. The present dispensation, even though, as I told, they are not happy with the minority right, they cannot take away, they cannot deny it. So things are happening at center, and the center is being a judicial commission. There is a system. In the state government, it's not a judicial commission, it's a state level officer, a secretary level officer is actually doing it. And the scrutiny is actually happening at the local level. So they are asking money, and even if it is not, they are not forwarding it, you cannot do anything. But center, it's a judicial office. And then for getting the minority status certificate from the center, the procedure includes the first step is that you need to give an application to the state. That's only this is a mere formality, nothing more. And then after 3 months from the date of submitting an application to the state, you can approach to the central government. And there are certain requirements, such as there is an amendment is required to be carried out in the memorandum, and there is required a specific affidavit is also needed, and a resolution is required to be passed in the governing body of that entity stating that you are proceeding to obtain minority status certificate, and you need to have an up-to-date recognition or affiliation also. These are the only requirements. And the whole process may take around 6 to 8 months, or in some cases it may take even 12 months, because if the documents are not ready, such as the affiliation is expired, then if it is taking some more time at local level, then it may take some more time. So this is what the approximate time period. And previously, before 2018, obtaining minority status certificate was so easy. We could complete it within 2 months of time. That is how number of institutions got the certificate much earlier. But nowadays, little more procedure. It is there to verify the credibility of that institution. There is a local inspection also has to happen. They will merely see, okay, this is an institution actually functioning or not, or closed down or not. There has to be a local report also has to come to Delhi, and that may take some time. So it may. That is a district collector will conduct that inspection. There is a 3-member committee: district collector, the minority welfare officer, and the educational officer. The inspection means they cannot ask so many things from you. There is a pro forma. They need to only write the name of the institution, what is the syllabus followed by that institution, and is that institution is affiliated or not, and how many students are studying in that institution from the minority. No, this is it's up to you how you are handling it, that matter. Legally, they cannot stop it, because the commission will ask them. Commission is sending a judicial order to them. Do an inspection and send the report. So they can delay it for 1 or 2 months of time. After that, they cannot delay it. So they may be saying, "Aapko jaisa report chahiye, aap thoda paisa de do, hum aapka jaisa de." That is not required for you. You should say that you fill it up and you provide as per your thing. You need to take a stern stand.
The last question, this is from concerning the minority students. The government, particularly from the Ministry of Minority Welfare, they have scrapped the scholarship for the students from grade 1 to 8, saying that these students are receiving the RT funds. But whereas in our state and many states, the central government is not giving any RT fund. Even the students, those who have applied for this minority, pre-matric scholarship, they are not getting any benefit from RT funds. So can they seek a relief from Supreme Court saying that we are not getting any relief? So we are eligible for scholarship. We have already fulfilled and submitted all these details. So can they seek a relief from Supreme Court?
It's a very important question, very pertinent question related to receipt of certain grants by the minority community. This was there earlier, but now for the last couple of months, it is all of a sudden it is vanished by stating that RT is already providing free ship for all the students. Then why do we want to have a separate system? That is what the logic applied by the Ministry of Minority Affairs. Please note that generally Ministry of Minority Affairs was controlled by a minister from the minority community. Even though it was from the present dispensation, Mukhtar Abbas Naqvi was the person who was heading that ministry. But now for the last 2 years, Smriti Irani is the cabinet minister who is controlling the Ministry of Minority Affairs. So naturally, somebody, the secretary who is advising this minister must have been informed them that, yeah, people are getting benefit under RTE. Free ship is there under Right to Education Act. So in some way, that is true. There are free ships as per RTE Act. Free ships are actually there. So additionally, it may not be required. That is what the logic they must have applied. But as he rightly pointed out, RTE Act is not applicable on minority institutions. So this issue rightly taken up by the Minority Commission. There are two commissions. The minority status certificate is issued by the NCMEI, National Commission for Minority Education Institutions. That's an education institution commission. Apart from that, there is another commission also, National NCM, National Commission for Minorities. So National Commission for Minorities took judicial notice on this aspect, and they have sought certain explanation from the Ministry of Minority Affairs. Even NCMA is also so concerned about this aspect, because they have done it purely on the basis of a mistake, because RTE Act is not applicable on minority school. So we hope that this issue will be rectified from the ministry level itself. But otherwise, you are free to approach High Court or the Supreme Court for this matter. Legally, there is no bar, but somebody has to come. Now, everybody will say, people will be thinking, okay, you may take up that matter, or he may take, ultimately nobody will take up. So somebody has to take up this matter. It can be. This is maintainable, because this is actually one of the facets of the minority right, and that is denied. So somebody has to take up this matter and proceed further. Yes.
Our learned speaker and a practicing advocate at Supreme Court has spent so much time, and he was very patiently answering to all the questions. So I hope all those who are present realized, and they got a lot of understanding, legal knowledge of rights of minorities and all. So on behalf of AMEI and the school leaders, those who are listening and watching you, as well as those who are in hybrid mode, all will be thankful to you for being here and sharing your valuable time with us, and sharing your knowledge and experience and all with us.